Definition of false imprisonment. What constitutes false imprisonment? False imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It basically involves any unlawful violation of the liberty of another. The ancient English legal scholar, Henry D. Bracton, 1200–1268, tells us that false imprisonment is one of the oldest violation of rights known. Forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. False imprisonment is classified as a tort under the common law, and also as a crime. It has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for a remedy. Depriving a person of their liberty is legally no different than depriving a person of their property. A theft of liberty is a wrong by which remedy can be had, just as is the case with the theft of property. False imprisonment is a great offense due to the high regard the law has for liberty. In Chitty's practice of the law it states, 3. The infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonments, or malicious prosecutions. 3. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the laying on of hands is not necessary to constitute an unlawful detention. 4. Thus the only essential elements of the action are 1. Detention or restraint against one's will, and 2. The unlawfulness of such detention or restraint. 5. In his treatise on the law of torts, Judge Cooley states, false imprisonment is a wrong akin to the wrongs of assault and battery, and consists in imposing, by force or threats, an unlawful restraint 6 upon a man's freedom of locomotion. Blackstone, in his commentaries on the law, 3 Bl. Com. 127, states on this matter, every confinement of the person is an imprisonment, whether it be in a common prison, or in a private house, or in the stocks, or even by forcibly detaining one in the public streets. 7. Thus any type of detainment or confinement of a person, or restriction or deprivation of their liberty or freedom of locomotion, where he is compelled to remain where he does not wish to remain, or to go where he does not wish to go, is an imprisonment. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment as being the unlawful restraint of the liberty of the citizen, or of the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, imprisonment is any restraint of the personal liberty of another, and prevention of his movements from place to place, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. 8. In reviewing several textbook definitions on false imprisonment, the Supreme Court of North Carolina stated, false imprisonment is the unlawful and total restraint of the liberty of the person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion. It belongs historically to the class of rights known as simple or primary rights. The theory of law is that one interferes with the freedom of locomotion of another at his own peril. 9. A rather complete description of what does and does not constitute false imprisonment was given by the Supreme Court of Kansas as follows. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone or by acts alone, or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined within a prison or within walls, or that he be assaulted or even touched. It is not necessary that there should be any injury done to the individual's person or to his character or reputation. Nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intention. Nor is it necessary that the act be under color of any legal or judicial proceeding. All that is necessary is that the individual be restrained of his liberty without any sufficient legal cause therefor, and by words or acts which he fears to disregard. 10 False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is a false imprisonment. False imprisonment is the name of the category for those torts that unlawfully deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room. 8 Griffin v. Clark, 55 Idaho 364, 42 p. 2nd, 297, 301 1935. Citing, Cordell v. Standard Oil Company, 131 Can. 221, 289 p. 472, 473 1930. Johnson v. Tompkins, 13 Fed. Cass. 840,853, No. 7416, 1833. 9 Riley v. Stone, 174 NC 588, 94 434, 440 1917. 10 Gurnier v. Squires, 62 Can. 321, 62 Pack. 1005, 1006 1900. Kroger v. Passmore, 36 Mont. 504, 93 Pack. 805, 807 1908. Jail, or other location. Definitions of false imprisonment usually come from unlawful restraints of this nature. False imprisonment has been well defined to be a trespass committed by one man against the person of another, by unlawfully arresting him and detaining him without any legal authority. I1 The law sets such a high value upon the liberty of the citizen that an attempt to arrest made unlawfully is esteemed a great provocation. 12 All the authorities agree that an arrest may be made either with or without a manual or actual touching by the 13th officer. Thus any illegal restraint of one's personal liberty by the act of another, gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie any restraint put by fear or force is unlawful. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual usually made by an arrest, and manual custody or restraint is not essential to the effectuation of an arrest. So if an officer tells a person that he is under arrest, and he thereupon submits himself to the officer, going with him and obeying his orders, such person is deprived of his liberty, and if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no manual touching or seizure, nor any resistance, the intentions of the parties to the transaction are to be considered. In 11 Regal v. High-Grade Seed Company, 47 Fed. Sup. 290, 294 1942. 1 to Giddens v. State, 154 Ga. 54, 113 386, 388 1922, 13 McAleer v. Good, 216 Pennsylvania 473, 65 Attle. 934, 935 1907. 1 4 Johnson v. Norfolk and W. Ryko, 82 W. Virginia, 692, 97 SE 189, 191 1918. 1 5 Mullion v. Adams, 144 MD. 355, 124 A 901, 904 1924. 1 6 Black v. Clark's Greensboro, Incorporated, 263 NC 226, 139 S.T. 2nd, 199, 201 1964. 1-7 Nos v. Ritchie, 155 127, 128 West Virginia 1930, 1-8 Turney v. Rhodes, 42 Ga. App. 104, 155, 112, 1930. 5 Such a case there must have been intent on the part of one of them to arrest or restrain the other, and intent on the part of such other to submit, under the belief and impression that submission was necessary. 14 The following definitions will provide further insight into the nature and elements of false imprisonment. False imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used the word false seems to be synonymous with unlawful. 15 Any exercise of force, or expressed or implied threat of force, by which in fact the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. 16 False imprisonment is the unlawful arrest or detention of a person, without warrant, or by an illegal warrant, or a warrant illegally executed. 17 Any restraint, however slight, upon another's liberty to come and go as he pleases, constitutes an arrest. 18